I've been attempting communications with her over the last 2 years and have given her every opportunity, which she has rejected. This has gone on for 2 years, so I'd like to move forward.
All right, if you both raise your right hand, please. Do
I,
you,
I, can I disagree to move forward because there are certain things that you don't know about this, I believe.
Mr. Ortega, that's what the trial's for. So I need you to raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I
Yes.
do.
All right. So, Ms. Castle, I'm going to give you 30 seconds just to do an opening statement. You don't have to give me all the facts. Just tell me why it is that you're suing her, why you believe, what amount that you're asking for, and basically that. Okay, if you can tell me real quick.
Okay, I was the tenant at the property from 2019 to 2023. I gave her over 30 days notice of my move out, which included my forwarding address to return the security deposit. I waited over 30 days for any communication with her. On December 12th, 2023, well over 30 days since I had moved out, I hadn't received my security deposit or any communication or a written description or itemized list of damages and charges. I sent her notice that it had been
Okay.
more than
Okay,
30 days
Ms.
and still
Castle.
did not receive it.
Ms. Castle, yeah, I just need to know that you're suing because you didn't get your deposit back and it's been more than a
Correct.
lot of time. Mr. Opea, do you
Correct.
want to give me an opening statement real quick?
Uh, well, yes, she was late 2 months in a row. The last late months that she lived there, by 14 days each month. And in October, when my institution put a hold on her check, she threw a fit, met me at my bank, tried to blame my institution for putting a hold on her check.
Okay,
And
so hold on just a moment.
their answer.
Remember, hold on, Mr. Opea. So remember for both of you, um, I'm trying to kind of narrow where we're at here, right? So if I'm asking you for a brief 30 seconds of an opening statement, Ms. Castle is just telling me I'm a tenant. I gave her a deposit. She didn't return it to me in a timely manner under the property code, and I'm asking for it back. Boom, we're done. For you, Mr. Opea, you simply say, um, I deny that because there are other charges that I'm billing her for, and so she owes me for these things, and that's why she didn't get it back. That's it. Okay,
Yes, for two,
that's what I
yes.
need to know. The bank issues are not relevant here. Okay, all right. So
This is the moment where the case truly narrows into a legal bullseye. The judge is stripping away emotion, side stories, and bank drama and focusing on one statutory question. Did the landlord comply with the state security deposit law? In most jurisdictions, including Texas, which this language strongly reflects, a landlord must do two things within 30 days after a tenant vacates: either return the full deposit or send a written, itemized statement explaining exactly what is being withheld and why. Not a conversation, not a text, not a memory of a meeting, a formal written notice, delivered on time. Late rent can be a valid claim, but only if it's properly pursued. It does not automatically cancel the landlord's legal duty to account for the deposit. This is where many property owners made a critical mistake. They assume moral justification replaces statutory compliance. It doesn't. So the real trial question becomes chillingly simple. Was a required written notice sent? Yes or no? And if the answer is no, the law doesn't ask why. It only asks when and whether the clock expired.
what I'm going to do is, Ms. Cass, I'm going to allow you to begin with your case. I will ask questions intermittently so that I can kind of, again, narrow the scope of where we're going and what we're trying to do here. And so the first thing I'm going to ask you is, tell me the time that you were a tenant there.
I was the tenant at the property from July 1st, 2019 until November 8th, 2023.
All right. And what was your deposit?
My deposit was in the amount of $1,300. I gave it to her prior to move-in the form of a cashier's check, and I submitted that as evidence that it was received.
Okay. So now go ahead and tell me then why it is you believe you're entitled to your deposit back.
On October 2nd, 2023, well over 30 days prior to my move out, I notified Ms. Tropea of my intent to terminate the lease and vacate the property on November 8th of 2023. I delivered the Texas lease termination letter notice via email, text, and I also attempted to deliver the document in person to her. Included on that notice was my forwarding address to mail the security deposit. I also told her in person, because she lived right next door to me, on October 7th, she accepted that notice. I asked her to respond to my email and sign the landlord acknowledgement, but she never did. I've included all of that as evidence as well. So I
When you
waited
moved
over the
out,
30.
when you
I'm sorry.
moved out on the 8th of November, did you give her the key on that day? In other words, did you turn over possession of the property on that date?
Yes, Your Honor, I did. As a matter of fact, I asked her to meet with me to do a walkthrough of the property so that I could hand her the key in person. And I was waiting for her. She texted back that she had somebody was sick or something and she couldn't make it. So she told me exactly where to leave it. I took a picture. I did. I sent her the picture. She accepted that. Took lots of pictures of the property. It was in perfect condition, cleaned, repaired, and so I didn't meet with her, but I left the key with her.
Okay. So Ms. Tropea, you're indicating then that, she moved out on the 8th of November. You accepted the key from her on that date. Is that correct?
Well, I wasn't there to accept the key. My daughter was going through something and I had to be with my daughter.
Okay. So who accepted the key on November 8th?
She just left it on the bar or something like that.
Okay. And
Left it inside the house.
when did you receive the key?
I don't know, a day or two later when I finished up with my daughter.
And you in fact did receive her notice that she was going to leave the unit on that date. Is that correct?
She did tell me that she was going to be leaving, but I didn't receive anything in mail or in email or in certified mail or anything from her.
But you were aware she was leaving on November
I
8th?
knew she was leaving, and she knew that she was 2 months behind on her payment and her late fees.
Okay, so what you're saying is she didn't pay her rent and therefore you kept the deposit.
Well, yes.
Okay, so when did you send her a notice or an inventory basically itemizing the damages or the rent and all those things? When did you send that to her?
When we met at my banker's office and tried to have a meeting with the vice president of the bank because she was blaming my institution.
What day was that?
That was in October. I believe it was on October 2nd is when they started the hold.
So October 2nd, she had not left the property yet. She's still there.
Yeah, but the $1,500 that she owed me, my bank wouldn't accept.
Okay.
And she was very upset that they wouldn't accept it. And when they put a hold on a bank, on a check, it's like in space or somewhere. They have no way of physically getting a hold of the check. And they gave her a very good solution of paying $24 to put a stop payment, going and getting me cash, because they said the hold was going to be at least 12
Okay.
days.
But I'm not here to discuss the issues between her and your bank, or you and your bank, or you and her and the bank. That's not what this is about, right? She's claiming that she's entitled to her deposit back.
But
And
she's
you're saying, well,
not, because she
ma'am,
owed late.
ma'am, and you're claiming that she's not because she didn't pay the rent, is what you're saying,
Yeah.
right? Now, tell me, and this is, again, answer my question that I asked previously, which is, when did you send her a notice that you were going to be retaining the deposit and the listed reasons that you were keeping that deposit?
I told her in the bank meeting that this was going to highly affect her deposit.
Okay, but the bank meeting was October 2nd, and she didn't leave the unit until November 8th. So tell me what day after November 8th did you send her a notice in writing that specifically stated you are retaining the deposit and the reasons for which you're retaining that deposit?
I don't remember that because like I
Well, I
said,
need that. So I need you to find it.
I don't have that.
Okay, did you not send her a letter then?
I I can't remember. My daughter was going through a lot of health issues. I was going through a lot of health issues. I absolutely do not remember that
Okay.
of
So,
sending anything.
so just so that you're aware, the law is very clear.
Mhm.
Upon leaving the unit, right, the rented premises, the landlord is required within 30 days to send in writing a notification to the tenant, I am retaining your deposit or a portion thereof for these reasons. And you have to itemize exactly what those reasons are. You have to delineate specifically what that is.
Okay.
So that's a requirement. It has to be in writing. It has to be delivered within 30 days. I need to see that.
I don't have that.
Okay.
At the
The
moment.
issue of non-payment of rent is not a factor here right now because
This is a legal cliff edge. The landlord has just admitted she cannot produce any written post-move out notice itemizing damages or rent deductions. And under the statute, that absence is not neutral. It is legally interpreted as bad faith. Bad faith doesn't require malicious intent. It doesn't require fraud. It requires only one thing: failure to follow the mandatory process. The moment the 30-day window closed without written notice, the law automatically presumed wrongful retention. And here's the brutal multiplier. Once bad faith is established, the court is no longer limited to refunding the deposit. It is authorized and often required to award treble damages, 3 times the amount, a penalty designed not just to compensate, but to deter landlords from ignoring statutory duties. So this case is no longer about $1,300. It's about whether procedural silence just triggered a $3,900 consequence, and whether decades of experience can excuse a single missing document. At this moment, the outcome is already mathematically forming, even before the judge speaks the number.
you could have sued her separately for non-payment of rent, for a breach of contract, any one of those things, or you could have brought it up in this case as a counter, like a defense, basically say a countersuit, saying she owes me X amount of dollars for non-payment of rent. Okay.
Well, I've never been through anything like this before, so I don't know how this works.
No, I
And
understand. This is complicated for your average person. It's complicated for attorneys. I can assure you that. But it's no less the requirement that, if you don't know, that's not a defense. It's certainly not an excuse to not follow the rules, the court rules, okay? If you're a landlord, then you're expected to know that the rules associated with the landlord-tenant relationship, that you're going to be familiar with them, okay? Let's go back a step here. Ms. Castle, were you renting a duplex, or is this a completely independent unit? What is this?
It's a duplex. I
All
was
right,
in unit B, she was in unit A.
and you're B, she's an A, okay.
Yes.
And Mr. Opea, do you own both of those units, A and B?
I do.
Okay. How long have you been renting Unit B?
For as long as I've owned it.
And how long is that?
About 28 years.
Okay. So you should know, either you knew or should have known what the rules are for notice when a tenant leaves a property. In other words, when you can keep a deposit and when you cannot keep the deposit. You should know. You've been doing this for a long time, right?
Sure.
Is that correct?
Hello?
I didn't hear a response. Okay, yes, I'm guessing that's what you said. Okay. So, I'm going to look at the complaint here again. The law states that the mere absence of a response in writing within the 30 days is evidence of bad faith. okay? And when bad faith is an element of this type of case, then treble damages are allowed. In other words, if you do not send a notice within the 30 days, on its face, that in and of itself, and you did not return the deposit, by the way, then that in of itself is considered bad faith, and therefore the plaintiff is entitled to 3 times the damages. In this case, she's suing for the $1,300 deposit because there was no notice given for retaining that amount. She meets the threshold for the bad faith, or I should say you meet that threshold for the bad faith. And so the judgment amount will be for $3,900.
Sir, I don't have $3,900. I'm about to lose my house.
I'm very sorry to hear that,
I
ma'am,
don't have that.
but the law is the law. You have to give it back. Now, you can
It's
speak to her.
back payment
You,
at
you can,
all.
you can speak to her and try and work something out, but under the law, that you should have given her the $1,300 back, or you should have at least told her why you're not giving it back to her. And the case in your particular
Why I
case,
wasn't giving it back to her
well,
because she was late
I'm,
2
I'm,
months in a row by 15 days each.
ma'am,
That's
but I'm
not
not
true.
here to argue
It
with
is
you about
true.
this.
That's not true.
I
And I
have
The
submitted
proof of
law
it.
proof
is the law,
that the
okay?
checks cleared, and your vice president at your bank told me that they were holding all your
Ladies,
checks because your account was in such default.
That is not
ladies,
true.
this is not relevant here, and we don't need to hear any of it, okay? Simply put, is that Ms. Tropea, you're required by law to give her that notification within 30 days. You didn't do it by itself, on its face, that constitutes bad faith. Therefore, she's entitled to 3 times the damages, and that's the $3,900. Again, you want to speak to her about it to work something out, give her the $1,300. If you guys are in agreement, that's between the two of you. But with respect to the law, I don't have anything else that I can consider here other than that issue. So,
Your
thank you.
Honor,
Good luck to you.
Your Honor, I'm also seeking reimbursement for my court costs and for the tenants council, the $100 penalty and
Yeah,
pre-settlement and
So
post-settlement.
the court costs are separate from the 3,900, so you are entitled to that. I'm not going to grant the $100. You're just getting the 3,900 under these circumstances.
And the court costs.
The 3,900 plus court costs. That's correct.
Okay, and not interest.
Well, post-judgment interest will start to accrue after today, but no interest
Okay.
prior to today.
Okay, I also had to hire a private server because she told the constable she moved to Houston. Is that so that's itemized separately than court costs from what Mary had told
Is
me.
that included in the fees that you submitted?
Yes, Your Honor, it is.
Private?
I mean, not under court fees, but on my invoice, it's included as ABC legal private server, $85.
Okay, so you'll be granted the $85 for the private process server.
Okay.
So the amount then is $39.85. All right. Thank you both. Good luck to you.
In the end, the ruling is clear, methodical, and unforgiving. The tenant proved proper notice, proper surrender of possession, and proper demand for her security deposit. The landlord, despite citing late rent, family hardship, and banking disputes, failed to meet the single legal requirement that mattered most: issuing a written, itemized notice within 30 days. That failure triggered statutory bad faith, and bad faith unlocked treble damages, transforming a $1,300 dispute into a $3,900 judgment, plus court costs and service fees. The judge made one principle unmistakably clear: experience does not override compliance, and personal hardship does not suspend statutory deadlines. This case is a powerful reminder that in landlord-tenant law, procedures protection for both sides. Miss a deadline, skip documentation, or rely on verbal understandings, and the financial consequences can multiply instantly. So now we turn it to you. Do you think the law is too harsh, or exactly strict enough to prevent abuse? Should emotional circumstances ever soften statutory penalties? And if you were the judge, would you have ruled any differently? If you found this case as shocking as we did, make sure to hit that like button Share your thought in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal deep dives.